Thank you for joining us today as we present information in regards to Title IX and Clery and how they relate to Crowder and therefore to you as a Crowder employee. It is required that all employees and students receive training on the components of Title IX and Clery on an initial as well as an ongoing basis. Therefore, there will be training requirements periodically, and we appreciate your cooperation in taking advantage of these opportunities to keep our college safe and in compliance. We are going to start out by giving a broad definition of Title IX and Clery, how they are separate, but also what they have in common. In looking at Title IX and Clery individually, Title IX is a federal law intended to end sex discrimination in all areas of education. Title IX applies to issues of program equity, such as in athletics, and also to sexual harassment and sexual assault. The Clery Act is a federal statute that requires institutions who receive Title IV funding, most commonly known as federal financial aid, to track and record campus crimes and then to report those to the Department of Education. Clery applies to all alleged Clery reportable crimes at all our campuses and locations. We will define Clery reportable crimes when we discuss the Clery Act in more depth. Crowder College is committed to fostering a work and learning environment where all individuals are treated fairly and with complete respect. It is and continues to be college policy that sexual misconduct by employees, students, visitors, or applicants for employment or admission is unacceptable behavior and will not be tolerated. If you are ever the victim of sexual misconduct, you need to know that the college will take your complaint seriously and will not tolerate retaliation of any kind. If you've been involved in behavior that could be considered sexual misconduct, you need to understand that you may be disciplined, you may even lose your job. Everyone is entitled to a working and learning environment that's free from sexual misconduct. Here are some basic facts about sexual misconduct. It is a form of sex discrimination. It's against the law and Crowder College policy. Anyone, faculty, student, staff, or visitor can be a victim of sexual misconduct, and anybody can be a perpetrator. Sexual misconduct victims can be male or female, and so can their perpetrator. A man can sexually harass another man, and a woman can sexually harass another woman. In the workplace, behavior would be considered sexual misconduct if it is unwelcome, based on a person's sex, and interferes with that person's ability to do his or her job. In an educational setting, sexual misconduct interferes with the student's ability to participate in or benefit from the college's educational programs or activities. Based on federal law, let's look at the Title IX Sexual Misconduct Crowder College Policy. Sexual misconduct offenses include, but are not limited to, sexual harassment, non-consensual sexual contact, non-consensual sexual intercourse, and sexual exploitation. Let's discuss each of these in more detail. When an individual is the victim of sexual harassment, the perpetrator is exercising power. Sex is simply the mechanism for exerting this power. Sexual harassment can be defined as unwelcome conduct of a sexual nature, including but not limited to unwelcome sexual advances, requests for sexual favors, or other verbal or nonverbal conduct of a sexual nature, including rape, sexual assault, and sexual exploitation that is sufficiently severe, persistent, or pervasive that it has the effect of unreasonably interfering with, denying, or limiting someone's ability to participate in or benefit from the college's educational programs and or activities. In employment, the harassment substantially interferes with an individual's work performance and can be based on power differentials, the creation of a hostile environment, or retaliation. In addition, depending on the facts, dating violence, domestic violence, and stalking may also be forms of sexual harassment. Gender-based harassment can be defined as unwelcome conduct of a non-sexual nature based on an individual's actual or perceived sex, including conduct based on gender identity, gender expression, and nonconformity with gender stereotypes. Sexual harassment involves objectionable conduct directed at another person because of his or her gender. Therefore, conduct that isn't even sexual in nature may be considered sexual harassment if it's directed at a woman because she's a woman, or at a man because he's a man. At least one court has ruled that a man's violent physical attack on a woman was sexual harassment because the attack was based on the woman's gender. That is, she was assaulted because she was female, even though there was nothing sexual about the assault itself. Here are a few examples. Several male employees sabotage the work of a female coworker because she is a woman. Even though the behavior is not sexual in nature, their acts constitute sexual harassment because their behavior is motivated by the victim's gender. Another example, a male employee constantly stares at a particular female employee for long periods of time while she is working. She tells him to stop, but he keeps staring. Even though the act of looking at someone is not per se sexual, unwelcome staring can be perceived as inappropriate if motivated by the victim's gender. What is meant by unwelcome? Behavior may be considered unwelcome if the recipient did not request or invite it, consent to it, or initiate it, particularly if he or she has indicated that the conduct is not wanted or that he or she finds it offensive. The fact that the victim has not complained does not necessarily mean the conduct is welcome. Welcoming some conduct does not welcome all conduct. Unwelcome conduct need not include intent to harm, be aimed at a specific target, or be repeated. On the other hand, if the individual actively participates in sexual banter without giving any indication that he or she finds it offensive, it will probably be considered welcome. But even where this may be happening, keep in mind that some people may feel they have to go along to get along, and whether they say so or not, find it objectionable. Some sexual comments and or advances are so blatant and crude as to be inherently offensive. These will almost always be deemed unwelcome. Let's look at the types of sexual harassment. There are three basic types of unlawful sexual harassment. Quid pro quo, which includes unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature that is rejected by an individual, and the rejection results in an adverse tangible employment or educational action to the individual. It is made or caused by someone with authority or influence over that person's employment or educational endeavors. Hostile environment sexual harassment includes any situation in which there is harassing conduct based on sex or gender that is severe and pervasive or persistent and objectively offensive, such that it alters the conditions of education or employment from both a subjective and an objective viewpoint. Retaliatory harassment is any adverse employment or educational action taken against a person because of the person's participation in a complaint or investigation of discrimination or sexual misconduct. Quid pro quo sexual harassment. Quid pro quo is a Latin term that means something for something, or an exchange of one thing for another. In the workplace, quid pro quo sexual harassment encompasses asking for sexual favors of some kind in exchange for special treatment on the job, or the threat of ill treatment if the victim will not consent to sexual favors. The sexual harassment may be verbal or physical, and the asking may be done either openly or implied. In any case, it must be unwelcome. Examples would include: a supervisor lets a subordinate know that he or she will be laid off unless he or she gives in to the supervisor's sexual advances. Also, a supervisor may suggest that he or she can help a subordinate get a promotion if the subordinate gives in to the supervisor's sexual advances. For students, quid pro quo sexual harassment would occur if a college employee directly or indirectly requires a student to submit to sexual conduct in order to participate in a college program or activity, or as the basis for an educational decision such as a good grade. In other words, the college employee makes unwelcome sexual advances, requests favors, or requests that the student give in to other verbal, nonverbal, or physical conduct that is sexual in nature. This is also true for student-to-student interactions. The harassment is unlawful whether or not the victim objects, is harmed, or gives in so as to avoid harm. When does an environment become hostile? In determining whether sex-based harassment has created a hostile environment, the institution must consider the conduct in question from both a subjective and objective perspective. It will be necessary, but not enough, that the conduct was unwelcome to the individual who was harassed, but the institution will also need to find that a reasonable person in the victim's position would have perceived the conduct as undesirable or offensive in order for the conduct to create or contribute to a hostile environment. For example, a woman who tells jokes with sexual content will have a difficult time showing that those kinds of jokes told in her presence offend her. However, that same woman, subjected to an unwanted physical attack, could meet the subjective test despite her enjoyment of sexual jokes because the attack is unwelcome and severe. To make the ultimate determination of whether a hostile environment exists, the institution must consider a variety of factors related to the severity, persistence, or pervasiveness of the sex-based harassment, including the type, frequency, and duration of the conduct, the identity and relationships of persons involved, the number of individuals involved, the location of the conduct and the context in which it occurred, and the degree to which the conduct affected one or more students' education. Let's talk about hostile environment sexual harassment in more common terms. In the workplace, hostile environment sexual harassment takes place when speech or conduct of a sexual nature is so severe, persistent, or pervasive that it interferes with the victim's work performance or creates an intimidating, hostile, or offensive work environment. For students, this type of sexual harassment could occur when a college employee's speech or conduct is sexual in nature and is so severe or pervasive that it limits a student's ability to participate in or benefit from an educational activity or program, or creates a hostile or abusive educational environment. Remember, hostile environment sexual harassment may also include intimidating or harassing conduct of a non-sexual nature that is directed at an individual or group of individuals because of his, her, their gender. Some examples of hostile environment sexual harassment may include talking about sex, telling dirty jokes, unnecessary and/or inappropriate touching, commenting on someone's physical attributes, showing sexually graphic or suggestive pictures, using demeaning or inappropriate terms such as honey or sweetie, using sexually suggestive gestures, sabotaging someone's work because of his or her gender, engaging in physically intimidating conduct like blocking someone's path, giving or promising favorable treatment to those who will consent to sexually related activity, and using crude and offensive language. It doesn't matter whether the alleged harasser intended to harass the victim. The conduct is evaluated from the victim's perspective. Many offenders may be completely unaware of how their actions are being perceived. For example, where the victim is female, courts apply a reasonable woman standard, asking whether a reasonable woman would have found the conduct in question so severe and pervasive that it created a hostile environment. Before we begin our discussions of non-consensual sexual contact and non-consensual sexual intercourse, we must define consent. Consent must be informed, voluntary, and mutual, and can be withdrawn at any time. There is no consent when there is force, expressed or implied, or when coercion, intimidation, threats, or duress is used. Whether a person has taken advantage of a position of influence over another person may be a factor in determining consent. Silence or absence of resistance does not imply consent. Past consent to sexual activity with another person does not imply ongoing future consent with that person, or consent to that same sexual activity with another person. If a person is mentally or physically incapacitated or impaired so that such person cannot understand the fact, nature, or extent of the sexual situation, there is no consent. This includes impairment or incapacitation due to alcohol or drug consumption that meets this standard, or being asleep or unconscious. In an educational setting, we must also discuss consent and disparity of power. In cases involving a student who meets the legal age of consent in his or her state, there will be a strong presumption that sexual activity between an adult school employee and a student is unwelcome and non-consensual. This information was gathered from the question and answers on Title IX and sexual violence, which was published by the U.S. Department of Education in 2014. The second form of sexual misconduct that we are going to discuss is non-consensual sexual contact. Non-consensual sexual contact is any intentional sexual touching, however slight, with any object, by a person, upon a person, that is without consent and or by force. The next form of sexual misconduct is non-consensual sexual intercourse. Non-consensual sexual intercourse is any sexual intercourse, however slight, with any object, by a person, upon a person, that is without consent and or by force. The final form of sexual misconduct is sexual exploitation. Sexual exploitation occurs when a person takes sexual advantage of another person for the benefit of anyone other than that person without that person's consent. Examples of behavior that could rise to the level of sexual exploitation include, but are not limited to, prostituting another person, recording images or audio of another person's sexual activity, intimate body parts, or nakedness without that person's consent, distributing images or audio of another person's sexual activity, intimate body parts, or nakedness if the individual distributing the images or audio knows or should have known that the person depicted in the images or audio did not consent to such disclosure and objects to such disclosure, and viewing another person's sexual activity, intimate body parts, or nakedness in a place where that person would have a reasonable expectation of privacy without that person's consent, and for the purpose of arousing or gratifying sexual desire. Now let's work through a few scenarios to test what we have learned up to this point. Remember that Title IX is a federal law intended to end sexual discrimination in all areas of education. It applies to program equity, sexual harassment, and sexual assault. Remember, it is defined as, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. Our first scenario. A female student feels uncomfortable attending class with another student who is offering to help with schoolwork in exchange for sexual favors. Is this a Title IX violation? If you said yes, you are correct. It is a form of sexual harassment. Scenario number 2. A male student is reporting that a former girlfriend, who is also a student, is following him to his car, classes, the cafeteria, and the restroom. The male student has told the female to stop attempting to contact him. He is missing class to avoid the contact. Is this a violation of Title IX? If you said yes, that is correct. It is a sexual misconduct violation and would be considered stalking. Scenario number 3. A student shares with her advisor that several weeks prior she went to an off-campus party, had too much to drink, and does not remember any events until she woke up the next morning with a man. She is now pregnant. Is this a Title IX violation? It is not. We would, though, offer the student assistance and resources. Now let's talk about your responsibility under Title IX. It is your duty to report all alleged Title IX complaints to a Title IX coordinator. The Crowder College Title IX coordinators are the Vice President of Student Affairs, Ms. Tiffany Slinkard, and the Director of Human Resources, Ms. Michelle Paul. The coordinators will conduct an investigation following the Title IX investigation procedures. They will address confidentiality and privacy with the parties involved. They will provide resources to the parties involved and will ensure that the parties are warned of retaliation. It is important that you understand your rights as well as your responsibilities under Title IX. If you are the victim of sexual misconduct, don't just take it, tell someone. Do make a complaint to Human Resources or to the Vice President of Student Affairs. The college will take it seriously. If you're afraid, take a friend, coworker, or teacher with you. The college will investigate your complaint and take prompt, effective action to correct the problem. The college will not make your complaint public, but we will have to tell people about it in order to investigate and take appropriate corrective action. The only people who will know about your complaint are those who need to know about it to get these things accomplished. The college will not allow anyone to retaliate against you for filing a complaint and will take action against anyone who does. The college also has responsibilities under Title IX. If the college knows or reasonably should know about a complaint, then the college is determined to be put on notice. The college is then required to take immediate action to eliminate the harassment, prevent its reoccurrence, and to address its effects. As a college employee, all of you have a duty to report a complaint. A complaint may be raised by anyone in the college community, including guests or visitors. And information reported to you is not confidential, but it is private.
What is the Clery Act? Just to give you some background, in 1985, Jean Clery was graduating from high school and choosing a college. She and her family chose Lehigh University in Pennsylvania. They chose Lehigh because of its smaller size, of around 6,000 students, pretty close to the size of Crowder. On April 5, 1986, Jeannie was asleep in her dorm room when a student she had never met before entered her room and brutally raped and murdered her. During the investigation that followed, Jean's family found out that there had been 38 violent crimes on Lehigh campus in the previous 3 years. If Jeannie and her family had been given that information, they might have made a different choice. Why is Clery important to you? Clery is a federal law that is tied to our institution's participation in the federal student financial aid programs. Current fines for violations are $35,000 per occurrence, and approximately 75% of our student population currently receives financial aid. Senator McCaskill is proposing an increase of fines to almost $150,000 per occurrence. The Clery Act is enforced by the United States Department of Education. We are required, as an institution, to identify campus security authorities, define Clery geography, and collect and disclose information about crimes that occurred on and around our campuses. The Clery team has already identified CSAs and defined Clery geography for you. We are not asking you to be experts on compliance regulations. We just need your help getting reports of any criminal activity to a CSA quickly so we can accurately report statistics. We will discuss classifications of reportable crimes a little later. We are required to maintain daily crime logs and fire logs, and we have only 2 business days to get the reported information onto those logs. We are also required to issue timely warnings about criminal activity that might be serial in nature and emergency notifications about situations that pose an immediate threat to our college community. This is the list of identified CSAs at Crowder College. We have attempted to include staff members who are in a position to receive reports and forward the necessary information on for inclusion in statistical reporting. Here is a basic list of our Clery geography by category. Notice that we are responsible for reporting for our 5 main sites, Neosho, Nevada, Cassville, Webb City, and McDonald County, 24 hours a day, 7 days a week, 365 days a year. We are responsible for reporting for non-campus geography only during the hours of use, but we are asking that if you are made aware of criminal activity in or near a space that is being used for official Crowder purposes, report it to a CSA, and we will determine if it needs to be included on statistical reporting. We have created Clery geography maps for all of our main locations. This is an example of the Webb City campus. You will notice there are sections of public streets that are included inside the red outline. We are also responsible for reporting Clery reportable crimes that occur on public property that is adjacent or within our Clery geography. This is the list of crimes that we are responsible for collecting and disclosing statistics for Clery reporting. All of the listed crimes, whether attempted or completed, must be reported when an allegation arises. When taking a report, it is vital that the CSA be given as much information as possible because there are further categories we are required to report that relate to bias and motive that we will discuss on the next slide. Any crime previously listed that was also motivated by one of the listed biases will be further categorized as a hate crime. There are also 4 additional crime categories that will only be added to our statistics if they are classified as hate crimes. It is your responsibility as a Crowder employee to help ensure the flow of information about criminal activity on Crowder grounds to a CSA. You are expected to direct students, staff, or campus visitors to a CSA to report allegations of Cleary crimes that appear to be in good faith, and you must do this in a timely manner. If the victim does not want the report to go further than the CSA will inform the victim that they are required to submit the report for statistical purposes, but it can be submitted without identifying the victim. In the event of an emergency, such as physical assault, you should contact campus security or call 911 as appropriate. You are not expected to take the place of law enforcement. It is not your responsibility to apprehend an alleged perpetrator of a crime. You should not insist that the victim contact law enforcement if they are choosing not to do so, but you are required to assist a victim with contacting law enforcement if they wish to do so. You should not try to make a determination as to whether or not a crime took place. The Red Folder is a resource for faculty and staff with information about assisting someone who may be exhibiting concerning behavior. There is information about when it is appropriate to share FERPA-protected information, warning signs of a student in distress, a stoplight guide to help determine when to refer a person in distress, a referral guide explaining which office to refer to in specific situations, a list of community resources, and some tips on responding to a student of concern. Each of our 5 main sites has a Red Folder with site-specific information. We are required to provide ongoing training on sexual violence prevention and alcohol and drug abuse prevention. We are also required to document and evaluate participation. These requirements apply to faculty, staff, and students. Sexual assault is sexual contact that usually involves force upon a person without consent, or that is inflicted upon a person who is incapable of giving consent. Some tips to preventing sexual assault are: no always means no. It is safest to stay with groups. Ensure you have money, a charged cell phone, and a way to leave a place that feels unsafe. Agreeing to one form of sexual activity does not mean that you or your partner agrees to all forms of sexual activity. Consent is clear, knowing, and voluntary. Consent is active, not passive. Silence is not consent. Clearly communicate your sexual boundaries and limits before engaging in sexual activity. Don't assume your partner wants to have sex with you just because you've had sex before. Alcohol and drugs will impair your ability to make safe, clear decisions and will lower your sexual inhibitions. Never leave your drink unattended, and don't accept drinks from people you don't know or trust. Sexual assault includes unwanted sexual contact of any type. Some risk factors for sexual violence are alcohol and drug use, being male, having friends who are sexually aggressive, witnessing or experiencing violence as a child, being exposed to social norms or shared beliefs that support sexual violence. Certain factors can increase the risk of harming someone else, but they do not necessarily mean they will do so. Effects of sexual violence may be physical or emotional. Physical effects may include chronic pain, headaches, stomach problems, and sexually transmitted diseases. Emotional effects may include fear and anxiousness, problems trusting or becoming involved with others. Anger and stress may lead to eating disorders, depression, or even suicide. Victims are more likely to smoke, abuse alcohol, use drugs, and engage in risky sexual activity. Doctors diagnose alcohol abuse or alcoholism when a patient's drinking causes distress or harm. Take a moment to review some of these signs of alcohol abuse. Alcohol abuse can have negative impacts on your life. Some of the risks include injuries, health problems, birth defects, alcohol use disorders, and personal problems. We encourage you to be an active bystander. If someone is at risk for sexual assault, dating violence, domestic violence, or stalking, consider it an emergency. Get involved. Don't wait for someone else to act. Some tips for intervening are: approach everyone as a friend. Be honest and direct. Don't be aggressive or use violence. Keep yourself safe. Get help from other bystanders if necessary. And call the police if a situation becomes too serious. Timely warning and emergency notification. Timely warnings are issued for criminal situations and will be distributed by the Director of Public Information via campus email, event link, and/or the emergency notification system. A timely warning will include all information that would promote the safety of all and would aid in the prevention of similar crimes. Emergency notifications are required to be distributed upon confirmation of a dangerous situation on campus involving an immediate threat, regardless of whether a crime is involved. Examples of emergencies that would warrant a notification are an active shooter, a gas leak, a bomb threat, tornado, or fire. We will conduct yearly tests of our emergency notification system.
Thank you for participating in this required employee regulatory training. Please return to the Blackboard training site and print out, complete, and submit the verification form to the Crowder College Human Resource Office.